Hi, everyone. I'm back with you all to go over another immigration update that has happened for this week. There's really, I'm sure there were a few other things that happened, but the executive order has so dominated the conversation this week that it's really hard to focus on anything else. So this is an executive order that is called the Proclamation Suspending Entry of Aliens Who Present a Risk to the U.S. labor market following the coronavirus outbreak. So it is sort of a continuation and exacerbation of, the April 2020 proclamation that suspended immigrant visas, essentially. So green card visas. And so this is kind of just goes further than that. So we're going to talk a little bit about the executive order and what's the impact, go over the summary there. Subsequent guidance that has been received through the various agencies since that time. And then in particular, since these are updates on academic and healthcare immigration, we'll talk about the physician and healthcare professional context. And we will also talk about the impact on universities. And finally, touch it off, as you'll kind of see in the executive order, that this may be, I don't want to say the tip of the iceberg necessarily, but that there are some other things to come. So we will talk a little bit about that as well. So the first part is, this order itself, it comes down, and obviously there's just a big impact that people are seeing upon businesses, upon hospitals, upon universities, and even, while we won't touch on this as much, the L category, which is for intercompany transferees. This is going to upset a lot of the international companies that send their specialized staff. Like, think about all the car companies, foreign car companies, sending their executives and, senior officers and just other specialized experts to the U.S. And basically the United States is saying, we don't want you here. We don't want your business here. So it really sends quite a message. And, there's certainly a concern over reciprocal actions. This may violate a few international agreements as well. There's been some speculation. So there could be some reciprocal effects from other countries as well. So the other thing I want to say is families may be caught up in this. And we're already seeing this issue of potential family separation. If you have somebody here who's on an H-1B, and they have their H-4 family abroad without a visa. So that's another concern. We've also seen, just in the healthcare arena, the residents and trainees who were supposed to start in H-1B status, that they could also be very impacted by the very narrow carve-outs for healthcare that may not impact them, the lack of guidance the embassies have. And so that's a big effect. They did specifically carve out, well, just by not mentioning the J1 physician category, but a lot of residents and trainees come on H-1B status. So that's another potential impact. So let's talk a little bit about what this does. So first off, it talks about, as I mentioned, the April 2020 proclamation. That's continued until December 31st, 2020, okay, at least for that immigrant visa ban, that green card visa ban. And then this executive order for H, L's, and J's, this also runs through December 31st, 2020, having come into effect 2 days ago on the 24th. But again, could very well be extended. And we'll see, it's an election year, so we'll see what happens. So what it does is it suspends H-1Bs and H-2B visas, as well as the family members accompanying or following to join, okay? Does it cover H-1B ones? Those individuals, it's sort of a common work status similar to the H-1B, but it's for Chilean and Singaporean nationals. Well, the embassy in Singapore says that they don't really have guidance on this, and so they won't be issuing H-1B1 visas at this point. So I would say, yes, that's very much still impacted too. So H-1B, H-1B1, H-2B, and then accompanying family members. Then there's the J category. Now the J category, as I mentioned, it's not a blanket, across the board suspension. they are suspending the ability to get J1 visas for certain categories only. So the J1 intern category, the J1 trainee category, the J1 teacher category, camp counselor, au pair, summer work travel programs. So when it says J1 teacher, that's a little bit confusing. And my individuals who work in the academic setting, right? If you have a concern about this J1 teacher category, our understanding is that J1 teacher, that's just that particular category that's for K through 12, K through 12 teachers. Okay, so yes, it does impact sort of that narrow category, but should leave unimpacted the J1 professors, J1 research scholars, J1 short-term scholars, those types of categories. But universities, will also be impacted in the H-1B context. A lot of their faculty, come on H-1Bs. So we'll talk about that too. And then, of course, we said the L1, yes, and of course the J2s, right? So the J2s under these particular categories, the family members. And then the L visa, and then those accompanying or following to join as well. So that is the suspension of entry. Now, it starts talking about how in Section 3 goes into the scope. So this only applies to individuals who are outside the U.S. on the effective date of this proclamation. Okay, so this is, what's unclear is, well, if somebody is inside the U.S. right now, but then they want to leave and they want to process one of these visas, like an H visa, will they be impacted, in their subsequent departure, even because they were here, when the proclamation became effective on the 24th? And that is somewhat unclear. The language suggests that those present in the U.S. can later travel for a visa, renewal when the consulates reopen. But we're still trying to get some guidance on that. We're still trying to get some guidance, but possibly they will be okay, just based on the plain language of this proclamation. And then it talks about, so it only applies to individuals who were outside the U.S. on the effective date of the proclamation and do not have a non-immigrant visa that is valid on the effective date of this proclamation, and do not have an official travel document, other than a visa, such as a transportation letter, boarding foils that you can get through the embassy, or an advance parole document that is valid on the effective date of the proclamation. Okay, so this, come to find, this does not impact Canadian nationals who are visa exempt. And I'll talk about that a little bit, but that guidance came out very recently. That was not something that was self-evident from this executive order. We were very unsure. But I think that has now been successfully clarified, that it does not impact Canadian nationals. Now, what about, does it impact somebody who does have a valid visa on the date of this proclamation, but maybe it's a B1, B2 tourist visa, maybe it's an F1 visa. So it's not the relevant visa that person would use to enter. They want to enter on an H-1B, but they just so happen to, as of the 24th, had a valid tourist visa, and now they need to go to the embassy to get their H-1B visa. Are they going to be impacted? It's unclear. It's unclear as of yet. So we're hoping to get some guidance there. It also says that it does not apply, so these are the carve-outs, right? It does not apply to any lawful permanent resident of the United States. It does not apply to any individual who's the spouse or child of a U.S. citizen. It doesn't apply to anyone who is seeking to enter the U.S. to provide temporary labor or services essential to the United States food supply chain. And it does not apply to any individual whose entry would be in the national interest, as determined by the Secretary of State, Secretary of Homeland Security, or their respective designees. Okay, so we have some pretty clear carve-outs here on permanent resident of the United States, or the family, spouse, child, right? So and when they say spouse, they're talking about when they talk about child, they're talking about minor child here. That's the the definite. It gets a little bit more complicated than that, but that's what they're talking about. And so those should be the clear exceptions. And then, essential to the U.S. food supply chain, I think there's arguments there, and the national interest definitely as well. And they talk a little bit more about that national interest exception when we get to the implementation and enforcement section, section 4 of this proclamation. So basically, this section 4 is this charge. They are giving a task to the Secretary of State, Secretary of Labor, and Secretary of Homeland Security to establish these carve-outs related to national interest, okay? And those carve-outs, they say including those that, right? So maybe these will be expanded or clarified, these national interest carve-outs, but they are including, as part of this proclamation, just generally those individuals who are critical to the defense, law enforcement, diplomacy, or national security of the U.S., those who are involved with the provision of medical care to individuals who have contracted COVID-19 and are currently hospitalized, those that are involved with the provision of medical research at United States facilities to help the United States combat COVID-19, and those that are necessary to facilitate the immediate and continued economic recovery of the United States. They're also talking about sort of a carve out for children who would be, turning 21 and potentially aging out of a green card process. Those rules get kind of complicated, but if there's a potential age out case of a dependent child, that could be something relevant as well, and I think that's probably not just green card age out. I would think that's potentially that's an age out on a non-immigrant visa as well. I mean, considering that this is a suspension for non-immigrant visas, but that's definitely something to figure out. So the carve-outs, right? So critical to defense, law enforcement, diplomacy, national security. I think that there could certainly be some research projects. Universities might have some arguments related to that through vital research. And also provision of medical research at U.S. facilities to help the United States combat COVID-19. So that's sort of a research, medical researcher possibility that there could be a carve out there. And you have the medical care to individuals who have contracted COVID-19 and are currently hospitalized. This is a very disappointing, narrow carve out that was not, it was definitely more general in the April 2020 proclamation, which was exempting, healthcare professionals, whether or not they were doing work related to COVID-19. This is much more narrow than that. And it's talking about not just treating COVID-19 patients, which many physicians are doing, but they're talking about those who are currently hospitalized. So what does that mean for physicians who are treating COVID-19 patients, and sort of subsidiary effects of the virus, but they work in outpatient settings? That's not clear either. And there's definitely a lot of advocacy going on among, some of the medical organizations to try to get clarity on this, because this carve out is, so narrow. What about necessary to facilitate the immediate and continued economic recovery of the United States? I mean, I think universities and I think, hospitals and academic medical institutions, I think there's a lot of arguments here. I know that there is, there's a lot of sort of ripple effects from physicians who come into, let's say, even rural communities, right? And they bring their knowledge and they bring their expertise, and they really can help the rural area, not just by healing the workforce. Really, that's an argument that physicians, they're healing this workforce to get back and to, help with that and fuel that economic recovery in the U.S. But also just their very presence, coming into these rural and underserved communities, they are generating economic growth in those areas. The staff that have to come in to help work with the doctor, all the infrastructure that needs to be put into place. There are some arguments related to economic recovery. So that's something that's important as well. We have some upcoming visa appointments for physicians who are outside the U.S., need to come in on H-1B status. And we're going to be trying to use letters that are showing this, economic growth, and also are showing just the work that they'll be doing related to COVID-19 patients. And so, we will see how things progress there. And I'll talk a little bit more about what we're seeing on the ground floor as well. Additional measures. Now, this is a concerning aspect here. This is Section 5 additional measures. And it talks about how the Secretary of Labor, in consultation with Secretary of Homeland Security, should consider promulgating regulations or taking appropriate action to ensure the presence in the U.S. of individuals who've been admitted or otherwise provided a benefit or are seeking admission or a benefit pursuant to like an EB-2 or EB-3 immigrant visa or an H-1B non-immigrant visa to ensure that they do not disadvantage United States workers. So it's concerning. I mean, there's a lot of, you can hear a lot of rumor and a lot of chatter and press about what's coming down the pipeline. But, I think that there's a consensus that there will be, that we haven't seen the end of things just from this executive order. We may be seeing some H-1B regulations. We may be seeing some regulations related to optional practical training. So this is sort of laying the groundwork there. It's kind of like the Buy American, Hire American executive order. Didn't say very much in wording, was very vague. And then it came out and it triggered all of these subsequent issues that we saw with specialty occupation, requests for evidence, and H-1B denials. So, there is another provision here about the DHS secretary will consider promulgating regulations, to ensure that the presence of in the United States of H-1B non-immigrants does not disadvantage U.S. workers. So we shall see. And then the other proclamation, the other sections are basically just talking about the expiration on December 31st, 2020, but they'll continue to monitor, which it could likely be extended, I would imagine. We'll see what happens with the election, of course. And then the effective date is June 24th, 2020. Okay. So there were a few other things in there. Don't really, in terms of just impacts to the academic and healthcare community, that's really what I want to stay focused on. And let me just say also, while we're talking about the summary here, our firm, Greg Siskind, has put together a travel ban advisor app. I am including the link here as well. There was so much interest that we had to put we ended up putting a charity paywall behind it to just kind of keep the app up and running because of all of the interest. So all the proceeds that are, I think it's $5 donation for running the app. The proceeds are going to immigrant to organizations that are doing very important work in this country. And so take a look at that. It talks about the pre-existing travel bans, the COVID-19 related travel bans, the April 2020 travel ban, and the current June 22nd executive order that we're talking about today. So please look at that too. Now, in terms of subsequent guidance, what are we seeing? So the American Immigration Lawyers Association did confirm with CBP that the Canadians entering as H, L, or J non-immigrants are exempt from the presidential proclamation. Okay, so that is guidance has been provided to local CBP ports on that issue. So that's some of the guidance that we're seeing out of CBP. And then there is just sort of a tweet storm from Department of State that kind of brought in, just answered different questions. It didn't give us very much in the way of details, but I thought there were two questions, Q&As that were relevant that I'll just put forward for this community. I am already in the United States on an H-1B, H-2B, J, or L visa. What does this mean for me? So it says the proclamation is not retroactive. No valid visas will be revoked under this proclamation. So that's definitely helpful that if you have a valid visa, it's not going to be revoked. I still don't think it's answered the question of those individuals who want to, who were present here on the date of the proclamation, June 24th. They want to leave and they want to get a renewal of their visa. Will they be impacted? That's just not, it's not entirely clear whether they'll have trouble with respect to renewals. Then there's another one about, I am a physician, am I exempt? So it says physicians applying for J visas are not subject to the proclamation. We know that already. Physicians seeking to enter the US on an H-1B or L visa, which would be uncommon, but of course they enter on H-1Bs, to provide medical care or are involved in research related to COVID-19 may be considered for exceptions. So it just says may be considered for exceptions. And it doesn't change the fact that the carve out right now is quite narrow, related to treating COVID-19 patients who are currently hospitalized. Okay, so we shall see what happens in terms of advocacy on that front. So what are we seeing sort of on the ground floor? There's just been, I believe that there was an appointment in Pakistan that there was a visa appointment that was canceled. We've seen the US Embassy in Singapore saying that they don't have any guidance yet, so they're planning to refuse or put into admin processing all H-1Bs and not do expedited appointments until they have guidance. That's one of my colleagues received that email. And also there was an issue in the US consulate in Shanghai. And I think just basically what's happening is that they're having the interviews in most cases, but they're saying that, they can't issue the visa because they have to evaluate further, whether the individual can be granted a visa due to the president's proclamation. I think in one case also, it was somebody who was the spouse of a US citizen. So that should have been an easy carve out, and the embassy was still kind of reluctant to rule and issue that visa. So we're basically seeing a lot of that admin processing issues. So that's kind of what we're seeing in the physician and healthcare professional area, because these were, by the way, these anecdotes that I'm giving are related to physicians, right? And we've certainly been seeing some issues with trainees who have been having problems because of this administrative processing as well. They want to come on their H-1B to start training, and they're having those issues. Now, just one other plug here. We are going to be doing a Zoom session. The physician immigration team at Siskind Susser is going to be doing a Zoom session on Tuesday. I believe it's at 7 p.m. Central. And I'm giving the link here so that you can see calls that we have done and will do, including this physicians and the new travel ban Zoom session. It's going to be presented by Greg Siskind, my colleague Elisa Taub, and myself. So please do join in. We'll be doing a deeper dive on physicians and the new visa ban. With respect to universities, the concern is just as it is with other other general business categories when we talk about H-4s, who are overseas and the possibility of family separation. We talk about H-1Bs who are coming as initial hires, right, coming from abroad to work at a university will be impacted. And there's oftentimes not as many options for faculty. Maybe there's an option for an O1, extraordinary ability status, which is not preempted by this proclamation, but you can't put tenured professors into the J1 research scholar role. So that's kind of the issue there. Now, F1 students, M1 students, J1 students, they are not caught up in this proclamation. But, and this is sort of our, segue into the next subject, possible OPT and H-1B rulemaking to come. We probably haven't seen the last of issues related to OPT. So I was on a stakeholder call recently with the President's Alliance on Higher Education and Immigration. And Paul Hughes, who's the attorney who's involved in the WashTech litigation case, which is related to whether OPT will end altogether on the basis of this litigation, was also talking about this. And, there's a belief that there's going to be substantial litigation that's going to come on this executive order. That's to come in all likelihood. But there are other issues just related to OPT and the potential desire to rescind 24-month STEM OPT and maybe even restrict post-completion OPT as well. I've seen one policy to restrict, or just some chatter, I should say. It's definitely nothing official, but to restrict standard post-completion OPT to only those in the higher end of their class, whatever that means. And just some issues with reforms to H-1Bs, like higher salary requirements, maybe also the H-4 EAD rescission, which is very strange because the government has already said that there's not, they already said something about there not being economic impacts related to them wanting to rescind H-4 EAD right now. And they were doing that in the Save Our Jobs litigation to end H-4 EAD. So there's just some very strange things here. Even in the WashTech litigation to end OPT, the administration is still defending that. They're still technically on the defense side. And in save jobs for H4 EAD, they are as well. So, but, things can change certainly, and we could be getting these kinds of regulations to reform H1Bs, put in higher salary requirements and things of that sort, and H4 EAD, change OPT regulations. And I should also note that it may not necessarily be a formal notice and comment rulemaking, which takes a long amount of time. They could try to do this as an interim final rule and try to explain, provide good cause as to why they are ending, without a formal notice and comment rulemaking, why they want this rule to go into effect immediately to end STEM OPT and things of that sort. So we will see what happens. Obviously, that puts it on even shakier ground litigation-wise, because if you have, there's a good cause exception, you really have to establish that good cause. And the other thing is just all of these, reliance issues on OPT. Students who've come in and they've been doing their course of study with the full belief that they would get OPT afterwards. There are important reliance issues. And in, DACA, unrelated topic, but related in a sense, in this Supreme Court decision that just came out, part of the reason why the rescission of DACA was incorrect and not properly justified was because the administration did not consider significant reliance issues, of those who are on DACA. So reliance issues could be another issue here, a possibility to really fight against any rulemaking that may come out. So yeah, I think that's everything I had today, and I appreciate you all tuning in. Again, hope to see many of you at the Zoom call that we're doing next week. And yeah, check out our Travel Ban Advisor app as well. So let's end this, and great. And we will see you all later. Take care.